Madam Chair, I have asked that this board be polled so that we can meet with the attorney. I feel much more comfortable on this issue, being able to sit down, ask some questions. Based on those answers, we may have more questions. This is not a letter, this is not something where we're sending it to him to say, is this within the law or is it not? I think this is a multifaceted concern. I have many questions, and I wish that we had met with the attorney so that tonight we could be acting with that knowledge. And I will ask it at this time because I think it's appropriate, Madam Chair. If this board polled to have in favor of meeting with the attorney, couldn't you talk to Dr. Littlefield and ask him to make an arrangement with the attorney?
There's a motion on the floor.
I'm speaking to the motion, Madam Chair. The motion is about sending the letter to the chair, to the attorney, and I am making the argument that I think it would be better served for this board to speak directly with the attorney. So I won't support this motion, but I will make a motion that we meet with the attorney regarding this issue.
Mr. Dunbar, you have your hand up.
Yeah, I think this is a odd situation in that if we're asking Dr. Littlefield, he's part of the SAU staff. And even though he was, the second letter, he was the messenger of the letter. My concern is, even though this letter is one incident, I think we have other incidents that are of concern, and not just primarily the one board member. So I don't know whether, we're obviously going to be expending taxpayer funds, that's number one. I don't know if Gordon specializes in this type of law, that's number two. I have no problem with having somebody who is versed in workplace issues as it regards to this. I will say that I guess I find it interesting because this issue came up over a year ago at the SAU level, and we established some resolutions at that point.
Point of order, Madam Chair. He is not speaking to the motion. This has nothing to do with business of the SAU.
Yes, it does. It's the same issue, David, just a different...
It is not the same issue. We never received a letter from administration at the SAU. Did we?
The attorney called us together because they were concerned about liability of the whole district.
Madam Chair, we're speaking to the letter. I would appreciate we speak to the motion. I would appreciate this board take some action and give the administrator some satisfaction.
I totally agree, David. Try to look at this 4 weeks ago, and you use parliamentary procedures to subdue it.
Madam Chair, I object. 4 weeks ago, we looked at a different letter, which I objected to based on the process. That has been resolved, Phil. Why do you bring this up? We're trying to move ahead with a letter that is of importance to the administration, that's been properly, that has been proper. No, I'm speaking to this letter.
No, you do not get to interrupt someone else who on this board who is
Why don't
speaking.
you stop him
Mr. Pearl,
not speaking against the...
he is speaking, and he is speaking.
He is not speaking to the motion, Madam Chair.
That's your opinion. I'm the chair.
Madam Chair,
It's not
he is
my
talking about the SAU business.
It has everything to do with
No, it
the same
doesn't.
thing.
You're out of order, Madam Chair.
Were you finished, Mr. Dembo?
I believe that screaming loudly doesn't make your point any more heard.
Mr. Dembo, I am not screaming. I am objecting to people that can't speak to the motion, who bring in unrelated stuff, and then try to tie me with something else. This has nothing to do with me. This has to do with a letter from the administrators.
This gets to the point of the administrators and also Dr. Littlefield's statements about fear in the district.
No, it doesn't, Madam Chair. The letter from the administrators is the letter from the administrators. That is the item we are on. Madam Chair, I'd like to make a motion that we set up a special meeting to meet with the attorney.
I'll second that.
Speak to my motion. Now that we're on the topic, this is the motion. I know nothing about hostile work environment. I was elected to the school board as a lay person. These some of these issues may have legal implications. I need to speak with someone and get advice face-to-face before I can move forward on this. It is in no reflection that I don't care to move forward or I don't care about these concerns. We have spent money for attorneys to figure out who said what and who's talking about stuff in social media and all kinds of crazy stuff. This needs to be dealt with. It needs to be dealt with correctly. We could end up with liability here, maybe working on good intentions and not do the right thing. So I would like to meet with the attorney either before our next regularly scheduled meeting or set a special meeting date.
The reason why I voted for the last motion was if we reach out to Gordon, obviously he can lead us in the right direction to get an attorney that deals with these type of issues. So I think he's probably a good focal point to start with to lead us to somebody who specializes in this. It could be the woman by chance that was at the SAU meeting, whatever, somebody that deals with these issues on a regular basis and has an expertise in these issues. That's why I said let's talk to him.
I may be mistaken, but I'm very confident that Gordon deals with these issues as long as he's been doing municipal law. I have no reason to think that he didn't. I believe that the reason that the SAU used a different attorney was that they wanted someone not related to the SAU or any particular school district. We don't have that problem here. We're familiar with Gordon. I think we could learn a lot from bringing him in and having a conversation.
So just one point. So the apology last time was predicated on the fact that John said that this was a joke and people didn't get his Christmas time humor.
I object, that is not what I
You don't get
said.
to interrupt another board member.
He is misstating what I said. What I said is on record now.
You are out of order.
He is out of order.
He gets to speak.
You need to correct him when he's not speaking to my record.
I was at the meeting. The apology was predicated on the fact that you said it was a joke. It's
You are
obvious.
wrong again,
It's-
Mr. Denbo. You are wrong. Read the record now before you make your statements. Don't just go from how you want to spin it with your memory. Read the record. Watch the video. Watch my words.
You have spoken twice, Mr. Pearl, Mr. Lescard.
Yeah.
I'm sorry, David. On this.
I was there that night when you said I spoke twice as well at the Pinkerton vote. I understand. You're going to let Mr. Denbo spin away, even though now we have these words in a record. This board is losing respect of the citizens because we don't follow procedure and policy.
Continue, Mr. Dembo. I'm sorry for the interruptions.
No problem. So, if you review the tape, and I don't review the tapes, I was there that night and when it occurred, and just what I just said when I was interrupted. So, obviously, at the time, the stuff that we had available, you could tell that was not the case, and now there's more supporting information that the principals provided that makes it evident that that's not the case. And at the end of the day, even if it was, obviously we shouldn't have board members joking about child abuse. That's all I'm saying.
Yes, Mr. Pearl.
Unbelievable.
Madam Chair, I think this conversation that's just occurred should show the board that we need to speak with an attorney. If nothing else, no matter what you think, this board needs some legal advice at this point. I do not want to move ahead without it.
Yes.
I think last time, the reason why we didn't speak about this was the fact that the letter was not submitted appropriately. Now the second letter, which includes the first letter, has been submitted appropriately. So the administrators obviously should have the chance either to speak to the letter or we should deal with it the best we can. If we run into areas where we may need some advice, then we go down that road. But again, they did it the correct way this time. We've got it in hand, we've got supporting documentation in hand, so we should deal with it.
Yes, Mr. Pearl.
Mr. Dembo, I am stating to you that I don't know where I may get into a position where I need legal advice. This is not my field. I need to speak with an attorney. I'm telling this board that we've served with for a year and spent many hours with the attorney that I don't feel comfortable, and I don't think anybody here has any more knowledge of these subjects legally than I do. The first thing we have to admit when we're school board members is we're lay people, and we need to know when to reach out and get some help. The discussion we have heard, I think, is an example to the public of why this board should get some legal advice, where we can sit down, ask some questions, have some back and forth. So I would ask you all to please consider my motion, to support it, so that we can sit down, find out what we can and cannot do, and then act appropriately.
So at the end of the day, I just want to make sure that we're taking care of this in a fairly timely fashion. Obviously, it's went on for a little bit, and make sure we address our staff's concerns. So at the end of the day, David, if that makes you feel better about meeting with the attorney, then I guess I'm okay with that.
I would just say in a timely manner, for 2 weeks, I have asked this board, this chair, to poll the board so that we could have a meeting. I was expecting us to have had that meeting so we could take any action deemed necessary tonight. I have not received any reason for this board not to be polled. And I think that is the cause of a further delay. But I thank you for supporting my motion.
So Tricia, again, I think I'm speaking 3 times, so I'm sorry, but I did see the fact on our SAU email that Tricia was trying to get a hold of Gordon. In the meantime, I believe she said was going to get back to you when she had something, and so whatever the reason is for the delay, I know obviously she's not trying to delay the process, she cares about the staff too. So whatever it is, let's move on, David. Like I say, I support your motion. If that makes you feel more comfortable and it's going to get things moving in the right direction, then let's do it.
I would like to be clear. I only asked the chair to poll the board to see if they were in favor of meeting with the lawyer. She said she's working on it. When I emailed and asked her, well, what do you mean we've had 2 polls? She didn't answer me. I was only asking because if the majority of this board was to not meet with the lawyer, we would not. But if it was, then I think we would start talking about dates and ways that we could have done it. So I just want to be clear, getting no response, no poll, puts us here tonight without legal advice, facing another week or 2 week period before we can address this issue.